Good morning or good afternoon, everyone, and thank you for joining AMMA, your National Resources and Energy Group, for our Thursday Workforce webinar. Can I start by acknowledging that we're all dialing in from various lands around the country, the traditional owners of which I pay my respects. My name is Tom Reid. I'm Head of Policy and Public Affairs at AMMA. I'm joined by my colleagues, Ben O'Brien, Head of West Coast Workplace Relations based in our Perth office, and Katie Jacklin, Principal Workplace Relations Consultant based in AMMA's Brisbane office. It's actually Katie's debut on our Workforce webinar, so I'll direct all the hard questions your way, Katie.
Thanks, Tom.
This webinar series focuses mostly on industrial and employee relations matters, but we also touch on any pressing broader workforce or industry matters as well. Today, topics include the fallout of the Mondelez High Court decision, some payroll and compliance matters, appropriate workplace behaviours and investigations, some COVID-19 workforce challenges, and some other IR policy developments. But most importantly, this format provides you all with an opportunity to tell us what is of most importance to you and to ask any questions that you have relating to employee relations and people practices, in particular in the resources sector. So no question is too basic, and if it's too complex or specific, we'll take it on notice and come back to you directly later on in the day. So just a quick note on the technology, excuse me. You've all come in here automatically on mute. Just given the large audiences who dial into these webinars, it's much more efficient for you to paste any questions or comments you may have into the questions box, which you can find within your user panel. So with that, we'll get straight into some of our topics. Firstly, Ben, we'll start with the Mondelez decision. Now, this was handed down by the High Court on the 13th of August, overturning the very controversial federal court decision. It's been a number of weeks, so the decision's been well read and fairly well understood. But could you give us a brief summary about the decision itself, but more importantly, how do employers actually apply that in practice? Because that's really been the key question since.
Yeah, thanks, Tom. The decision in Mondelez was really concerned with the NES requirement to provide employees with 10 days of personal leave and what 10 days equates to in a number of hours. It's pretty well established that full-time employees working Monday to Friday, 38 hours a week, receive 76 hours of personal leave in a year. But really the question in the Mondelez decision was what happens when an employee works a different pattern of work, say on a different kind of roster or working a different number of hours in a day. The circumstances of the case were that the employees in question were full-time employees and they were working a compressed hours arrangement. So they were working their full-time hours in 12-hour shifts and not 7.6-hour shifts or 7.6-hour days. And the employee's argument was that the length of their workday was 12 hours and therefore their annual personal leave accrual should be 120 hours in the year, which is 10 days times 12 hours being the length of their shift. The Mondelez argument was that the annual personal leave accrual should have been 72 hours a year, which is based on their full-time load of a 36-hour week and not a 38-hour week. So the decision went all the way to the High Court, and the High Court last month ruled in favour of the Mondelez argument, saying that one day refers to a notional day consisting of 1/10 of an employee's ordinary hours of work in a 2-week period, or for patterns of work that don't always follow a 2-week cycle, the entitlement can also be calculated as 1/26 of an employee's ordinary hours of work in a year. So it was widely reported because it was potentially a decision that was going to affect every business in Australia that's in the national system. The headlines, I think, lauded the decision as a win for business, but at the same time, we started to receive questions from our members about, well, that's great, it's a good win, but how do I actually apply that to my own employees' working arrangements? So in order to, I suppose, unpack that for people, we know that resources industry employees generally work rosters and patterns of work that aren't Monday to Friday 38-hour weeks. And so in order to work out how much personal leave that person should accrue in a year, really you need to apply what the High Court applied in the Mondelez decision, which is applying that 1/26 of the ordinary hours worked in a year, and that equals the number of hours of personal leave that an employee is meant to be accruing. So for employees covered by an award, that's pretty straightforward. So if you've got an employee who's got an employment contract underpinned by a modern award, the requirements of the award are generally pretty clear in relation to the number of ordinary hours that a person can work based on their roster, and that's averaged out over the roster cycle. So, for example, if we talk about the mining industry award, which applies to a lot of AMMA's members, whatever roster you've come up with for your full-time employees, the ordinary hours of work have to come out at 38 hours a week. And so 38 hours a week times 52 weeks is 1,976 hours of ordinary time in a year. 1/26 of that is 76 hours. So that employee would be accruing 76 hours of personal leave in the year. And of course, when the person takes a day of personal leave, you deduct the amount of ordinary time that they would otherwise have worked on that day. And that's where it does get a bit tricky, because the NES is phrased as saying that an employee will receive 10 days of personal leave in a year. But essentially what the High Court has done with its ruling is to say, well, some employees won't actually get 10 days. They will receive 10 notional days. So an employee working, for example, a roster where they are working maybe 10 ordinary hours on a day, if they take a day of personal leave, you deduct 10 hours from their personal leave accrual, which at the end of the year means that they're not going to have been able to take 10 full days off work, paid days off work, but they would have been able to take 10 notional days off work. So really, for employees who are in the award space, it's relatively clear what the accrual and deductions need to be. For employees who are covered by an enterprise agreement instead, it may not necessarily be as clear. The enterprise agreement itself may have its own rules around personal leave accrual and deduction. And if the enterprise agreement is approved, you have to assume that it will be an accrual or an entitlement that's better than equal to or better than what's in the NES. So you do have to have regard to what your enterprise agreement says about personal leave accrual and deduction. And it can get a bit tricky, because sometimes enterprise agreements go into things like defining what a day is, and that can be relevant for determining how much to deduct and pay someone for a day of personal leave. It can be a bit tricky, but if your enterprise agreement is either silent on personal leave or outsources it back to the NES, those same award type of rules would apply there. Probably the only other thing to keep in mind about the Mondelez decision is for employees who are working kind of a non-standard, they're not working 38 hours Monday to Friday, and for those employees, when they are taking a day of personal leave, you are required to pay that person only for the ordinary time that they would be working on that day. But most rosters are configured on the basis of a component of ordinary time plus an amount of rostered overtime, particularly if you're kind of working 12-hour shifts and that type of thing. So it's important to be clear when you're setting up your rosters how you're apportioning those hours, how many hours you're determining are ordinary time hours, how many hours you're determining are rostered overtime hours, in order to be clear about how much somebody should be paid when they're taking a day of personal leave. But also, I think a further consideration is if a person is taking a day of personal leave and by doing so is in effect going to be paid less for having the day off, it can encourage presenteeism. Some people are less inclined to take the day off work sick if they think they're going to lose a certain amount of pay. And especially in the present circumstances where everyone is hyper vigilant about illnesses in the workplace, it is, I think, something just for people to factor into their thinking about how they want to manage this going forward. Of course, the High Court ruling in Mondelez has set out the baseline, the minimum that people need to be doing, but we're aware that there are many of our own members who have elected to provide a more beneficial personal leave accrual and deduction system than the one that was found to have been appropriate by the High Court last month. So there are a couple of things which I think are important coming out of that Mondelez decision. And of course, it's probably incumbent on people to revisit their own arrangements now and just to make sure that they understand how they've structured their own personal leave accruals and deductions for their workforce, and to at least be aware of whether they're doing the minimum or have elected to do more than what is required.
Thanks, Ben, and we will get onto some of those other compliance and auditing issues in a moment, but I just want to answer a couple of questions. So someone's asked about the status of the issue of casual entitlements to annual leave. So this really comes to the heart of the WorkPac v. Rosato determination, which in terms of the latest status, so WorkPac has sought leave to appeal that to the High Court of Australia, and we're still awaiting the High Court to determine leave to appeal. But it is, of course, in terms of the test cases in the IR space, Mondelez was one of them, and thankfully the employers got a win there. And then the Rosato case relating to casual entitlements is another massive area, which we're still awaiting the outcome of. Just separately, many of you would be aware that the federal government has been undertaking these industrial relations working groups, looking at 5 key areas of IR policy. I will give you a bit of a status update on a couple of those groups a bit later on, but on the casual employment issue, one of those working groups is looking at the 2 main problems there. The first problem being legislating a more clear definition of a casual employee into the Act, which will sort out or clarify this issue going forward. And then the other one, which is probably more of a worry in this current economic climate, is dealing with the potential for huge back pay entitlement claims. And there are, of course, several class action lawsuits on foot there. So we're watching the Rosato case and the pending High Court appeal very, very closely, and we'll give you all an update on the next steps there. Just another question relating to the Queensland wages theft legislation. I'm happy to take that one because I've actually got some notes here anticipating this question. But yes, yesterday Queensland did pass what they're calling their wages theft legislation. So this basically means that employers who engage in deliberate wage theft face jail terms of up to 10 years or 14 years if fraud is involved. Also, the Queensland government's established a process through the Queensland Industrial Relations Commission to speed up or further support Queenslanders who believe they've been underpaid by their employer, a new streamlined small claims process, if you will. Unions, the Queensland unions are calling for the government to establish guidelines for the police to actually enforce this legislation. They argue that the Victorian legislation, which has been in place since June, that Victoria actually has an industrial inspectorate to investigate those matters, whereas Queensland doesn't. So there could be a little bit more movement in that space as well. While we're talking about wages theft, one of those working groups that I mentioned is actually federal government working groups is actually looking at the issue of compliance and enforcement, because the federal government does intend to also criminalise the most serious forms of deliberate worker exploitation or underpayments. They did release a discussion paper in February that focused on underpayments penalties, and that's continued on a theme throughout these working groups. AMMA's position is that these sorts of underpayment penalties, criminal sanctions specifically, is far from ideal to be putting criminal penalties into the IR laws, but it is an area that's been very high profile, and the unions have been campaigning very significantly for. So it's something that will, that will happen. And AMMA's position in terms of a federal system is that it will be better, like in other areas like labour hire licensing, for example, for the federal government to deal with it at a federal level, as opposed to our members having to manage multiple state jurisdictions that all may have some varying provisions in there. So if there are any other further questions on the wages theft laws, please pop them into the box, and we'll try and get to them with the remainder of this webinar. Ben, we'll just stick on the compliance matters for a minute before Katie will give you a chance to talk. We'll just get some of this through some of this content. Ben, you've been doing a lot of auditing work for our members. So there's the Mondelez case. There's a number of other things going on, annualised salaries in awards. There's some casual loading changes. Can you give us a bit of an update as to what's going on in that sort of space and the kind of things that AMMA's members are asking you and your team to look into?
Yeah, I think certainly the issue of compliance with the requirements of industrial instruments or the Act, it's going to continue to be a pressing concern for employers, and not only because we're starting to see the introduction of underpayments legislation in jurisdictions like Victoria and Queensland, and it's in the process of being introduced here in Western Australia. But it's just, I think, something which has become embedded in the industrial parlance now. The concept of wage theft or underpayments isn't going away. It's going to continue to be pressed by unions and employers, and for that reason, we certainly have been kept reasonably busy in relation to work and assessing people's compliance with their enterprise agreements or with awards. And I think really the thing for our members to keep in mind here is that this is really something which is an ongoing requirement. It's not something. It's not a set and forget type of situation. You really do have to pay very close attention to this all throughout the year. And not only because the rules continue to change. We saw earlier this year a number of modern awards updated to introduce these new requirements in relation to the payment of annualised salaries, and we've talked about that on these webinars at some length. But also at the same time, the Fair Work Commission at the moment is currently going through a process of consolidating all modern awards in relation to how casual loadings interact with overtime rates of pay, and is proposing that awards adopt one of three approaches on that particular issue. So either that overtime penalty rates get paid in substitution for casual loading, or the casual loading and the overtime penalty rate are added separately to a minimum hourly rate, or that the overtime penalty rate is applied to the ordinary hourly rate made up of the minimum hourly rate and the casual loading. So I like how simple the Commission is proposing to make this going forward. But this is something which industrially has always been the subject of some debate, and the Fair Work Commission is now embarking on a process of trying to change all awards to embed these rules in them. Now, if you weren't aware that was something that was potentially changing, and if they are changed in a way that's inconsistent with the way that you are managing casual loading and overtime payments, look, it might not be an issue if you pick it up within a couple of weeks or a couple of months. But if you didn't pick it up for a couple of years, that's where those small changes compound over time, and you're left with a massive headache at the end when an employee raises it with you, and that's why we've seen such large underpayment issues being reported in the media over the last 18 months or so. So it's very important to keep abreast of the changes that continue to happen to awards and other industrial instruments. Things like updates to the minimum wage. On 1 November this year, a number of further modern awards will have a 1.75% increase to their minimum rates of pay, and there'll be a further increase to other modern awards early next year. So it's important to keep on top of those changes and to make sure that when you are assessing compliance with industrial instruments is to really embed that as an ongoing process inside your organisation.
Thanks, Ben. And to any of our members who are looking at some of these compliance issues and audits and so on, that's right up Ben's alley. So be sure to flick us a note on that. Katie, workplace investigations. So this is something that yourself and your support team on the East Coast has been doing a fair bit of lately. Can you give us a bit of a flavour as to what are the sort of issues that our members are experiencing and what you're being called in to look at?
Sure, thanks, Tom. Yeah, I've definitely noticed that there's been an increase in the amount of investigations that we've been assisting with over the last 6 months. And whilst I won't go into any of the specific details about those investigations, obviously there are a couple of things that I can add as some pointers for our members to think about. Obviously, whilst each investigation is different, I think it's important to consider that an investigation should be conducted as if at some point in time it could end up before the Fair Work Commission or other relevant jurisdictions, obviously depending on the nature of the investigation. So it's something important to bear in mind. It's also important to consider whether the investigation should be conducted either internally or externally. And also that the scope of the investigation and the findings need to be clearly explained and understood by all of the parties, so that depending on what the outcome, the findings are, that moving forward, the outcomes are, because it could end up in potentially a termination, or making sure that relationships are kept and can be moved forward. Also, if you are conducting the investigation internally, something that's come up a little bit lately is just ensuring that the person that is conducting the investigation, ensure that they are actually appropriately trained and experienced. And if you've got some people that have been doing investigations and struggling a little bit, just there's some training programs out there. AMMA does provide that as well, but make sure that they are getting that training. Something else that comes up obviously is that you need to ensure that you're following all of your company policies and procedures. If you are noticing or you're getting feedback that your procedures are overly complex and far too difficult to navigate, now's a good time to look at them and see what changes can be made, so that there's you're not creating an inadvertent error or ability to make an error. That's all I've got to. Thanks, Tom.
Yeah, there's certainly been some high-profile cases bringing some attention on appropriate behaviours in the workplace. The AMP case, of course, which has been all over the Financial Review and other newspapers, and of course the Human Rights Commission handed down its report on workplace sexual harassment a little while ago, with various recommendations that we do expect the government will pick up many of them. So that there's certainly some attention in this space. Look, please. Keep flowing in your questions. I've got a couple of questions here about COVID issues. Ben, I might start with you because, of course, Western Australia, as does our state, Queensland, have a hard border close. And throughout this COVID-19 period, Western Australia with the FIFO workforces has been a challenging area. How have members fared over the past couple of months since we last provided an update on this issue?
It's certainly continuing to be a difficult issue to manage for our members who are trying to bring employees into Western Australia for work. I think really the biggest difficulty people have had is with some of the inconsistent application of the rules. The rules have certainly seemed to have settled into, I suppose, a more concrete form now, but the way those rules are applied on the ground by the personnel from WA Police aren't always consistent, and the WA government is certainly continuing to encourage people to move to Western Australia for work rather than to continue on a fly-in, fly-out type of arrangement. to the extent now that employees who are applying for what's called the good to go pass to actually get into WA to go to work are receiving, I suppose, a response from WA Police that more or less says, we're going to allow you to come into Western Australia as a once-off, but you might like to take this opportunity to reconsider your options in terms of moving to WA, because we probably won't allow you to come back in again, which is quite extraordinary, really, when you think that what that's asking people to do is completely uproot their family and their lifestyle to move to the other side of the country. Now, there has been some press just recently about WA's need or ongoing need for employees from all around Australia, and that the island within an island approach is certainly not going to be sustainable, especially given some of the larger projects which we know are going to be pushed forward in the next couple of years. So look, it remains to be seen as to when there might be some relaxation of WA's hard border stance, but everyone remains hopeful that that's going to be sooner rather than later. Hopefully WA's approach of going it alone doesn't last too much longer.
Yeah, thanks, Ben. I think we reflect that sentiment over here in Queensland, although we probably haven't had quite the extent of troubles that Western Australia has had. Katie, do you have any comments about what our East Coast members are experiencing in terms of these border closures and travel restrictions?
Yeah, sure, I do. Obviously, it's been in the media lately that each state has a different approach to what is considered as a hotspot. And as of yesterday, I can see that all states except for Victoria require a border pass, but the border pass requirements in each state are very different. So it is definitely creating further challenges for our members in terms of being able to move their people around, particularly with their FIFO workforce. And some members are trying their best to get people into the country by going through other borders, but it is quite challenging and difficult. I do have some members that I spoke to back in March, and we started to chat again just because we didn't expect these border closures to still be such an issue today. And some of our members have been considering things like state of origin employment contracts in the future, and other potential fixes in the future.
Yeah, thanks, Katie. We'll wrap up. We might run just a few minutes over, but just a question here on the superannuation guarantee increase. We're not hearing any talk of that being frozen, particularly given that the next increase, I think, is in June next year, and that would go from, 9.5% to 10%. I'll confirm that, unless Katie and Ben can confirm that off the top of your head, but I'll confirm that and flick that attendees asked that question just to note. But from what I understand, we're not hearing that it could be frozen at this point. Hopefully the COVID crisis is well behind us by the middle of next year, and we can start to see some recovery. Just a quick wrap up on the progress of the government's IR working groups that I alluded to earlier. The last meetings are being held over the next week. The two that AMMA is most directly involved in is the Enterprise Agreement Making Group and the Greenfields Agreements Group, which is obviously for new major projects. I can't really give too much specific details on an open forum like this, but I will just say that it's quite unlikely that there's going to be a solid position of consensus reached between the employee representatives, being the unions, and the employer representatives, including AMMA and others. But it has been a productive process that will guide the federal government in its legislation or its legislative making process, which we expect the government will move on a couple of these key items fairly quickly, possibly before the end of the year. Greenfields agreements has always been one that, in AMMA's judgment, the government has felt that could be a bit of a common sense reform, that being allowing major projects above a certain capital value to access Greenfields agreements that go beyond 4 years to better cover the full life of their construction phase. So that'll be a really important amendment to the Act to encourage future investment and I guess the next wave of new major projects and the thousands of jobs that will come with that. Enterprise agreement making is a bit more of a difficult area because there's just so much in that. There's a lot of things that the unions want. There's a lot of things that employers like AMMA members want. Look, I look forward to giving you all a bit more of an update on some of those specific outcomes and some of the things that have been discussed and mooted for reform once this process wraps up in about a week or so. But yeah, as it's undergoing at the moment, just can't get too specific at the present time. A couple of things just to remind you all. AMMA does send out what we're calling our employment snapshot, which is a 2-page update on all of the key industrial relations and related workforce legislation that comes out the first Thursday of every month. If you aren't receiving that, please get in touch and we'll make sure that you're on the list for that. And the same also with our news update, the AMMA news update, which is every second Tuesday, includes that fortnight's worth of updates on employment law, industry issues, any important political developments, and so on and so forth. The email to send your details to is policy@amma.org.au. If you could send through your email, if you're not receiving those two communication products, please send us an email and we'll ensure you're on the list for that. There's a few questions here floating in. We'll have to take those on notice, and I'll get back to each of you later on this afternoon. But thank you for your company today. Thank you, Ben. Thank you, Katie. And we'll see you all again very soon. Have a great one.